My lord, kindly come to page 27.
Who is appearing? Mr. Chaudhary, you are appearing?
Yes.
Yes.
Page 27, my lord.
Yes.
First of all, my lord, page 27, kindly see, this has been given yesterday. Although it was 13th April, it was given yesterday. In view of the apprehension expressed from various quarters, we do not know the quarters, regarding possible irregularities during the process of counting votes. Irregularities during the counting is in your hand. How can you say the irregularities? With a view to ensure transparency, the order conduct of counting process, the following protocol arrangements are proposed for strict compliance account. At least one among the counting supervisor and counting assistant at each table shall be central government / central PSU employees. I am challenging this one, clause 1.
Yes.
Now, it is issued from the office of the Chief Electoral Officer. Kindly come to page 28.
Yes.
Who has signed additional Chief Electoral Officer, West Bengal. My first point is, it is beyond the jurisdiction.
Yes.
First point is beyond the jurisdiction.
Yes.
My lord,
Then
first, my lord, lordships, kindly come to page 47. This is a page 34. This is a handbook for counting agent, page 34. Kindly see, my lord, 1.3. The following persons can be allowed inside the counting hall.
page.
Page 34.
Yes.
Counting supervisors, counting assistants, and micro observers.
Clause.
Clause 1.3.
1.3. Yes.
Counting supervisors, counting
Assistant and micro observer.
These are already appointed long back.
Yes.
Then 2 persons authorized by the ECI. ECI means Election Commission of India. Possessing authority letter duly issued by the ECI and observers. Therefore, any other persons, if the central candidate employee have to be taken, this has to be authorized by the Election Commission of India. Then public servants on duty in connection with the election. Whoever not involved with the election, all of a sudden you are bringing them as in the counting. You are not there. Even the public servant has not been codified under the Representative People's Act and the rules framed there under. Then if the central government is a public servant, I take it, Millard. Central government is a public servant. Then he has to be part of the election process. Who was not part of the election process, he cannot be done. He cannot be brought. He cannot be brought.
So as per this 1.3, these are the persons who can continue to be in the counting hall.
Now, Millard, kindly see, kindly come to page 47. 9.11.
Yes.
Apart from one counting supervisor and one micro observer for each counting table, one micro observer would be seated in each of the 14 counting table. The micro observer will invariably be central government PSU employees. There are only the micro observers.
Yes.
That is accepted.
Yes.
The micro observer will note down and details of the exercise by the EMS being counted in each round as so and so. There is no scope of the central government employee to be brought as counting supervisor.
Counting supervisor and
counting assistant.
Counting assistant.
Only in case of micro observer. Yes. One micro observer. Now let kindly see the Election Commission of India, Article 324, Sub-Article 2 of the Constitution.
Yes, 324.
324(2). The Election Commission shall consist of the Chief Election Commissioner and such number of other election commissioners, if any, at the President may from time to time fix, and the appointment of the Chief Election Commissioner and other election commissioners shall, subject to the provisions of any law made in that behalf on Parliament's transfer. Therefore, the election commission has been defined. Effectively, I tell you, Lord, the chief electoral officer role, chief election of electoral officer, the losses will not find any act. What is prescribed? That is not the returning officer, assistant returning officer, and election commission. Chief election commissioner has no power to issue any directions.
Yes.
324(1), kindly see. 3. The superintendent's direction and control of the preparation of the election rolls for and the conduct of all elections to Parliament and to the legislature, every state, and election to the office. Control supervision is vested with the election commission, not with the chief electoral officer.
Yes.
And Milord, your lordship knows, Milord, the principle BS Binas Tasha. We should. BS Binas 84. The BS Binas case, the lordships have gone that if procedure is fixed, you have to go by your procedural law. Whether it's a guideline or whether you are saying that it is your guideline. Election Commission guideline. The beyond the Election Commission guideline, one cannot pass. Even the Milord. Just 1 minute, Milord, kindly give it. I will just. Milord, these are the main points. I will just show 1 or 2 paragraphs. Kindly come to paragraph 16.
So how you are affected?
It is central government employee. But if it is beyond the jurisdiction law, but then I have to say what has happened yesterday. But there are points which I have raised in the one of my petition, which was dismissed here, and the Supreme Court has said, because of the paucity of time, we are not in a position to decide, because entire returning officer, etc. But Supreme Court has said, these are all important questions of law has been decided. We are keeping it open. The question is, if the returning officer is appointed, just I am taking, in complete violation of law. Why is central government employee? Why you are insisting on central government employee who is not involved in the any election process? I can understand, Milord, the CISF, CRPF for the law and order. That's all right. They are taking it. I am not on that. Returning officer, who will be the returning officer has been defined. Returning officer at the level of the subdivisional magistrate. Subdivisional magistrate of a state.
Correct.
Everybody has been defined. Assistant returning officer has been defined. Counting supervisor, etc. has been stated. All are state employee. Why you are bringing central government employee? More, your lordship is saying why I am prejudiced. In itself, in the complaint itself, it has been order itself. It has various corners from whom you have got it. Particular one political party.
Okay.
Whether it is a particular to one political party, who are that? Why did you not disclose? Well, there are meetings are held. Why did you not disclose? These are the complaints are coming. All of a sudden you can't say that. And 16, latest appears to be on 60th April. The 60th of April, what you have presumed? Irregularity. You are saying that the irregularities. If you apprehend, kindly read page 27 again. In view of the apprehension expressed from various quarters. In which quarters? Where is the writing? If it is writing, why you have not disclosed it earlier? We have to deliberate. What type of? Regarding possible irregularities. During the process of counting votes, do you disbelieve the state government employees? Entire election you have done with the assistance of the state government employees.
So whether they have already appointed the counting or this counting supervisor, counting assistant.
Counting supervisor, the original counting supervisors have been appointed.
No, that's why.
Yes.
Leave aside this order. Before this order,
Yes.
But
Who are the counting supervisors? Let me tell you, lords. Who are the counting supervisors? In various levels of the election, your lordships will find returning officer, presiding officers, micro observers, not only from the central government, state government is also there. So many observers there. And all are state government employees. So far, the observers are concerned only from the central government. But in the main election process, let's take it, Millard, from the presiding officer. Presiding officer. Who are assisting the presiding officer? They are all state government. Returning officer, state government.
Correct.
DRO, state government. Everybody is state government. Now, to remain in safe, then you delete observer. Why the observer? When the observers are there who are the central government employee.
Okay.
And paragraph 16 I am showing to you, lordships. Kindly come to Millard, paragraph 16. The petitioner is unaware of any similar notification having been issued by any of the other 4 states. Why the state of West Bengal you are taking discriminatory attitude? Well, 2,500 companies have been brought here. If one company was at Pahalgaon, these 26 persons were not killed.
Let's not go into
No.
From yesterday we are hearing. Let's not get into that. Let's stick to the law.
I am sticking in the law.
Yes.
Yes, I am sticking in the law.
Let's stick to the law.
Yes.
I personally don't want to go into any of this. I just want to show from the I'm appearing for a statutory body.
I will not finish.
No.
Here also you will not give the right of hearing. You don't give the right of hearing anywhere.
This court will give.
No. He
In a conference,
he means his client.
his client.
He means not he.
Millard,
His client doesn't want to hear anybody.
Millard,
Don't worry, this court.
I know. But that is the reason we are. Otherwise, we would have been wiped out long back.
Millard, let us.
Right from here to Supreme Court.
Millard, he gets a right of audience in a conference with Mr. Banerjee and has got so for 20 years.
Yes.
His client may be at loggerheads. Once he finishes, I'll be not done.
Loggerheads, if you say, then I will have to show.
You are filing a
Yes,
petition.
Loggerheads, if you say loggerheads, yes, the loggerheads. What you have done to us, yes, I have filed a petition, I was present there. Get out. Don't say, Mr. Chaudhary, don't open your mouth too wide. Don't move. Just 1 minute, Millard. Give me one thing. Yes, my BS Binas case, 1983, volume 4 SCC. Page ta koto? Starting from? Judge, page ta bolo na, okay, to the citation ta dite hobe. 582. Madam, kindly the paragraph 23. Jao Joseph ke bar kore. Read out. The next question that arises for consideration is whether the appointment of respondent number 4 as director of respondent number 1 is illegal because of non-compliance with bylaw 2 so and so. In the instance case, it is admitted on both sides that no publicity whatsoever was given in respect of the vacancy. The contention of Sri Gorg, however, is that the bylaw having no force of statute, non-compliance with its requirement cannot in any way affect the appointment of respondent number 4. They cannot say that is no statutory effect. They are saying is a constitutional power has been given to us. Just contrary.
Here is the constitutional effect.
Huh?
Here is the constitutional effect.
Constitutional. The guideline itself is similar. Is a power which has been given by the constitution.
That's why. That's why he is having the constitutional effect on that.
Effect on that. This, however, contended that assuming that the bylaw is not a statutory, even so, respondent number was found to comply in support of this content. It is well settled rule of administrative law that an executive authority must be rigorously held to be standard by which it professes its action, to be judged, and it must scrupulously observe those standards on pain of invalidation of an act in violative of them. This rule was enunciated by Mr. Justice Frankfurter in Vittel Sigaton, where the learned judge said an executive agency must be rigorously held to the standard by which it professes its action to be judged. Accordingly, if dismissal from employment is based on a defined procedure, even though generous beyond the requirement that binds such agency, that procedure must be scrupulously observed. This judicially evolved rule of administrative law is not firmly established, and if I may add right, so if that he that takes the procedure sword shall perish with the sword. This is line. The aforesaid principle of Swanso is applicable in India. Swanso quoted in Swanso. Now, interestingly, I just not for this case also remember If in view of the point of this code on the point of transfer, if the bylaws have been
That
framed for the
he-
conduct of it to avoid arbitrary, cannot therefore escape the liability for not following the procedure. Compliance with this bylaw also seems to be necessary in the name of fair play.
In the vacancy.
Fair play in action is required. Milord.
Yes.
If the fair play is not there, but these are my arguments.
Thank you.
The long and short of it is under, my lord, if your lordship sees, my lord, the returning officers handbook, my lord, clause 15.7.9. Lord, I'll just show it, my lord, from this. That we've sent for a photocopy. Please see, my lord, 15.7.9.
What is this?
My lord, this is the
Handbook of?
returning officers handbook.
Yes.
Counting 15.7.9. It's, my lord, detailed as to who's to do, my lord, counting. Please see 15.7.9.
Yes.
Counting staff appointments should be made in the form given in Annexure 35. Counting supervisors should preferably be gazetted officers, Group B or above. Counting assistants should also be Group B or at least Group C officials of the central or state government or officers of comparable status from central or state government undertakings. All appointments have been made
No,
in
no.
the procedure under
Please
this.
list the last line.
Yes,
Officials of the central government or state government.
Yes.
And officers of the comparable status
from the central or state government undertakings. So, my lord, it is central/state government.
Correct.
My learned friend's argument is, why is it from the central government? Answer is, it is permitted
Hmm.
by this. Law mandates.
No. Counting staffs.
Yes,
Appointment should be made in the form given in Annexure 35.
yes,
Counting supervisors should be preferably by the gazette officer first.
yes.
That's the first
Yes.
criteria. Gazette
Should
officer.
counting
Group B.
supervisors should preferably be gazetted officers,
That is the
Group B or
first
above.
criteria.
Yes.
Correct. Now second.
Counting assistants, Lord, I'll read it for your lordship,
Yes.
Lord. Counting assistants should also be Group B or at least Group C officials
Ah.
of central or state government or officers of comparable status from central or state government undertaking. So, long and short of it, either officials of central or state government or officers of comparable status from undertakings of central or state governments. This is, my lord, the law.
Okay.
ECI, my lord, has made appointments exactly in terms of this.
Okay.
One political party cannot, my lord, come and complain that the wisdom of ECI's appointments is wrong. Please see the writ petition. What is the complaint? Lord, please come to, my lord, page 37. This is the only legal argument. I'm sorry, it's not 37, 34.
Yes, 34.
Yes. 34, section A. This is the only document, my lord, shown.
Yes.
What is the argument? My learned friend showed, my lord, section A1
Yes.
and, my lord, in particular 1.3.
Correct.
And says following persons can be allowed inside the counting hall, which means any of the categories mentioned thereafter duly authorized.
Yes.
Now, appointments have been made under 15.7.9, read with, my lord, the relevant notifications, and they, my lord, will be entering and doing it. So, my lord, there is no difficulty at all. What is his argument? My lord, shorn of everything else. The argument is, how can you exclude state government officials from appointment? My lord, that is, my lord, the domain of the election commission. Whether, my lord, the law permits appointment of either central government or state government officials. So central government officials have been, my lord, appointed. It is not for one political party to come and, my lord, tell, my lord, the
But
Yes.
subject to,
Yes.
okay, you have shown the law. Subject to, if there is an objection, By
Yes.
central government. Can the election commission cannot adjudicate? Yes, okay. Central government, state government. Why you're not going for this state government also?
That is the wisdom of the election commission
I
to
am
not
that's
avoid
why-
any form of
that's why-
allegations.
That's why I'm telling. If a objection is raised with regard to some person,
This is not an objection with one person.
okay,
This is
some both.
objection with regard to a class.
Okay, one class.
One class.
One class. And
Yes.
the class, he is not asking the class which is not in the law. Not in the law.
Correct.
Correct.
Yes,
Not
this
in
is
the law.
permitted.
It is permitted.
Permitted.
If it is permitted, why the adamancy by both the parties?
We've already made appointments. Countings on
That's when-
Monday.
when the appointment was made.
Milord, appointment was. They've been made, Milord, on.
That's why I wanted the first question I put to Mr. Banerjee when the appointment was made.
Yeah. Sir, after Milord, I don't have the exact date, but it's already been made because counting. We are on Thursday. Tomorrow is 1st May holiday. Counting's on Monday.
Correct, correct.
And counting, Milord, your Lordship will appreciate what the only argument, Milord, is that persons authorized to do the counting are not authorized. I show your Lordship, they are authorized.
Correct.
Milord, this is not a place for, Milord, sentiments of one political party. It's, Milord, a judicial scrutiny. I'll come to the second aspect, Milord, of maintainability. It's, Milord, a question of judicial scrutiny of, Milord, discretion exercised by the election commission in respect to the process of elections. Yes, if it was wrong, your Lordship, Milord, possibly can say it's wrong. Your Lordship is a constitutional court. But, Milord, this is not wrong. It's state or center. Milord, employees. So, central government employees have been selected. So, Milord, there is nothing wrong shown. It's not an act done contrary to statute.
Okay. Next.
Milord, now, Milord, please have a look at the writ petition. No, no, Galagal. Milord, I am not, Milord, I am here to argue legal points. Milord, please have a look at the, Milord, the basis of the petition. Kindly, Milord, see paragraph 6. Milord, this is what the petitioner, Milord, showed your Lordship.
Yes.
Then, Milord, 13th April 26, notification. Then, Milord, paragraph 8. Petitioner is the main opponent, which admittedly runs and controls the central government.
Yes.
And then, Milord, well known that the central government, Milord, Lordship sees, Milord, paragraph 8. Milord, I'm not reading it because, firstly, Milord, it's contentious. Secondly, Milord, I don't want to read it. It is well known that central government PSU employees would be directly under the control of state government and are likely to be susceptible.
Central government.
Yes. Milord, please see this. It is obvious and well known that the central government, central PSU employees would be directly under the control of the central government and are likely to be susceptible to the suggestion and control of persons in the BJP. Such direct control of BJP over the central government, central PSU employees gives rise to an apparent risk of bias, influence, partisan conduct during the process of counting of votes. In comparison to the number of central government and such, there is no identifiable state government employees who may be present in terms of the handbook of counting agents. So therefore, this is arbitrary or without jurisdiction. So the basis of the petition, Milord, there are three, Milord, important issues which, Milord, the petitioner would have to establish to get orders. Number one, a central government employee would be directed to commit illegality in an electoral process. A whole class of persons are susceptible to illegal conduct because they are central government employees. Secondly, the central government whether the government or it's the PSU, would, my lord, give illegal instructions and have, my lord, votes counted at elections in an illegal manner. The highest form of illegality. This is the second presumption. The third plank is that a political party,
No, but the central government and PSU can give an illegal.
illegal instruction. This is the basis, my lord, of the paragraph. And this is the only, my lord, this is the plank of the petition. That A, the person counting would do illegality. He is a central government employee, but he'll do illegality. He'll, my lord, rig counting of votes. Second presumption is that those at the helm of the central government or of the PSU would, my lord, give illegal instructions to these persons to, my lord, rig counting of votes. And third is, my lord, a political party at the center would, my lord, have all pervading control over all central government employees who have been asked to, my lord, count votes through, my lord, those in command of these, my lord, PSUs or, my lord, government departments, for this illegality to be, my lord, pervaded. Now, all of this is presumption and not something your lordships, my lord, in the absence of material, because your lordships, my lord, proceed on the petition. Your lordships see material. If there is material, your lordships, my lord, come forward to do justice, to ensure, my lord, that justice is done. But, my lord, paragraph 8 proceeds on presumption.
Yes.
There is no material to persuade your lordship that this state of things can happen.
Yes.
Now, my lord, please see paragraph 10. The aforesaid, my lord, this is the notification. And then, my lord, handbook of counting agents. And then arbitrary. That's the end of it, really. And please see paragraph 20. This is a classic.
Paragraph.
20.
Yes.
The immense ratio of central government representatives is likely to create an atmosphere of fear, intimidation, and coercion amongst other individuals present at the counting table. You know, where is the material to show this? Why this presumption? They are also government employees. The state government employees are also government employees. The election commission, my lord, in its wisdom, have, my lord, chosen a set of central government employees to do this job.
Yes.
So, my lord, point number one, if I may repeat up to now, point number one is that there is no legal basis for the petition.
Yes.
I have referred to, my lord, 15.7.9 of the returning officer's handbook. There is no legal basis. Now, second submission is there is also no factual basis. I have shown the petition to show that this is on a perceived notion of, my lord, the world being against, my lord, the petitioner. And this honorable court, my lord,
Is that totally objection?
no,
you
don't
can't say
object. This is
No,
your
no, no.
petition.
Look, world being means what do you say? What?
I am proceeding on your petition.
Said, I will use-
Mr. Bandyopadhyay,
No, no, Mr.
I respect you.
Sorry.
I will not
Sorry,
shout at you.
No, no, I am not that.
You are
What
getting
Mr.
worked up.
Mr. Chaudhary. Please,
I am on
please
the
make-
basis.
Make
You
your
got the
legal
point.
and whatever the fact.
No, I am,
Not what is the
Huh?
petitioner, what is the response. Please.
my lord, I am proceeding on the basis
Yes,
of the
yes.
petition.
Yes. Tell me.
The petition says, makes these allegations, and my submission is there is no material to suggest this.
That I have taken note of it.
That's my submission. Number two, there's nothing else there. So no legal basis, no factual basis. Now my third legal submission. My lord, please have a look at Article 329 of the Constitution. My lord, last 2 weeks we've been showing this article, my lord, in large number of
I'm
times.
happy that the Election Commission is trusting on Article 329. First time.
Yes, yes, yes.
Last 2 months we are, this 4 months, including Supreme Court. They said 329 is subject to 324. Nothing is 329. But I am happy today they are saying 329.
Yes.
I remained, my lord, unflustered. I have a lot of respect for Mr. Bandyopadhyay. I've acted as his junior.
But I have to say that.
I don't want to get into this.
Please, yeah.
So what am I doing? You are interrupting. I am arguing.
Sometimes you are giving lecture. You are-
Millets, I also appear for Election Commission of India. Millets, my turn may also come a little
Yes,
later. My lord's permit.
No, I am for the CEO, my lord, West Bengal. Mr. Naidu, my lord, is for the Election Commission of India. My lord, I'll be very brief and leave him, my lord, to deal with, my lord, the constitution. My lord, we are relying on 329. And just one statement, because I know Mr. Naidu will be arguing the law on this, so I don't want it to be replicated. He will, my lord, deal with this aspect of the matter. I just want to create two, my lord, distinctions to all the other cases. My lord, number one, your lordship said, my lord, that this is when we, my lord, other matter, that this is an administrative matter. So I have to see. But this is not an election matter. Who counts the votes?
But
Your lordship,
but can you read the 329B?
yes.
Can this will go to the election petition? You satisfy me, I will pass an order herein now.
No,
If this,
of course this
if
can.
this type of the matter.
Of
will
course
go to
this
the-
can. Of course, my lord. Why not, my lord? May I just put this may I put a situation? Say, for example, in, my lord, a particular state, there is, my lord, some anomalous condition found with respect to counting of votes. That is, my lord, a cause for challenge to the election results. Of course, it can go. And the distinction, my lord, is between this example, which I give your lordship, and, my lord, a situation of, my lord, motorbikes or, my lord, the other matters which have come before your lordship. This is directly in the heart, my lord, of the election process. Secondly, my lord, alternative submissions, Article 226. Your lordships have said, my lord, Article 226, last minute in these matters is not to be lightly entertained. And, my lord, I'll request Mr. Naidu to, my lord, make the rest of the submissions on law. In case I have some extra judgment, I'll show your lordship at the end.
Yes, Mr. Naidu.
May it please, Millets.
Yes.
Millets,
Just, my lord, I'm sorry, Mr. Naidu, just one sentence.
yes.
By 27th of April 2026, counting personal appointments were all done. That's what, my lord, my instructions say. By 27th April 2026.
27th April.
Yes. We were on 30th. It was all done.
Okay.
Your lordships wanted a date.
Yes. When the Mr. Bhattacharya, when this letter was issued,
Which one?
13th April, but it was given only on yesterday. We have said so. No meeting, it was disclosed. Kindly come to me at page 10. I have 22. And not a, which is not written here, or not written here. Not, there are meetings are being held. Not any single meeting, it has been disclosed. Regular meetings with the political parties are being held.
yes, Mr.
May it please, Millets. With
Yes.
regard to the observers, this issue was raised earlier, and that was negatived by the learned division bench of the Calcutta High Court. They have taken that to the Honorable Supreme Court, and there the Honorable Supreme Court has refused to interfere with that order, but it has left the questions of law open. I am given to understand the petitioner's contention is, since that question of law has been left open, we can re-agitate even before the Honorable High Court, seems to be the gravamen of the argument. May I just take your lordship to that judgment, Millets, which was rendered very recently. Identical plea was raised. I'll just read a couple of paragraphs and then I'll take my lords to whatever that's material as far as the statutory provisions are concerned. In the judgment, my colleague would supply minutes,
Yes.
the division bench judgment. Has it been supplied to your lordship's minutes?
Yes, got it.
Kindly see minutes. Para 7. Para 7 of the judgment.
Yes.
Section 20B of RP Act of 1951 is relied upon, and it is contended that observer has to be from the same state. Much emphasis is laid on the word government used in Section 20B. By taking this quote to the dictionary meaning of the government from Black's Law Dictionary and Article 20 of the Constitution, he submits that the word government means the concerned state, which in the present case is state of West Bengal. Article 367 of the Constitution and Section 3, subsection 23 of General Clauses Act were relied upon to submit that the word government used in Section 20B must be read as state government, that is government of West Bengal in the present case. Sri so-and-so submits that the ECI may place reliance on certain handbooks and manuals issued by it, but no such guideline can prevail over the Constitution and the summary provisions ingrained in Representation of People Act 1950 and 1951. My lords may kindly come to page 19 and para 34. Para 34 minutes.
Yes.
So-and-so learned counsel for the ECI reiterated its stand and placed reliance on explanation appended under Section 20B of the Representation of People Act 1951. It's urged that this explanation negates the contention of so-and-so learned senior advocate that observer can be appointed in the same state to which he belongs. For this purpose, he also placed reliance on Section 3, subsection 23 of General Clauses Act to explain that definition of government includes central and state governments both. Would my lords come to para 38 minutes? Para 38.
Yes.
On a careful reading of the petition in general and para 28 in particular, leaves no room for any doubt that petitioner has not disputed the existence of power with ECI to transfer, shift the officers after issuance of election notification to ensure free and fair elections. My lords have seen. Then my lords could come to para 40. Page 24, bottom minutes, para 40, 40.
Yes.
In the instant case, it's clear like noonday that petitioner has raised eyebrows because sizable number of officers were transferred by ECI. In view of the aforesaid pleadings, where existence of power of ECI to transfer shift offices is admitted, we are not inclined to conduct any roving inquiry and analysis to examine whether the ECI otherwise had any such power or not. Then their lordships went on adjudicating all issues and have said that since you have not questioned the vires, the power of the Election Commission of India, they have got all the discretion and the power well within their purview, being a constitutional body, to conduct elections in fair and transparent manner, the way they deem it proper. For that purpose, especially the issue of observers, has not found favor with the Honorable Division Bench as far as the petitioner's consent. The same petitioner, or rather the petitioner supported. It is another PIL that's been filed before the learned division bench. This is one thing, Millers. Now I deal with the issue with regard to Millers, whether the question of law has been left open. Does that mean, in my humble submission, the judgment that's been rendered stands obliterated so that everything gets reopened even at the level of the Honorable High Court? Could my Lord C. Millers, I just read one sentence from the order dated 16/4/2026, the Supreme Court's order. It must have been there, Millers.
Yes.
Could my Lord C. Millers, though the petitioner has raised some substantial questions of law which might require consideration, however,
Yes.
keeping in view the election schedule in the state, we are not inclined to entertain the special leave petition. My lords may kindly appreciate, Millers, at the threshold, there is a refusal to entertain the SLP. That means the next sentence, the special leave petition is accordingly dismissed. Millers, as far as Article 136 is concerned, unless the Honorable Supreme Court goes into the merits of the matter, the doctrine of merger does not apply. So the first premise of my submission is that, Millers, the judgment rendered by the learned division bench of the Honorable Calcutta High Court stands firm as far as the Honorable Calcutta High Court is concerned, and it is the precedent for co-equal and other benches.
Yes.
Only the third paragraph, my lords could see. However, the question of law is kept open.
Yes.
That means, my lords, as far as the Supreme Court is concerned, perhaps whenever the occasion presents itself, it may consider that one and rule on that one. But as far as the judgment that's been rendered, refused to be interfered with, stands firm vis-a-vis the Honorable High Court. That's why, my lords, it can't be heard. They're saying, no, it's been completely opened up and that got obliterated. The very dismissal of the SLP speaks volumes about that, is my humble submission. Then, my lords, let me come to the...
Then you clarify in the paragraph 3. However, the question of law is kept open.
Yes, my lords.
This kept open because special leave petition is dismissed. So that special leave petition is not before the Honorable Supreme Court to decide the question of law. Now the question of law is kept open. So who will decide the question of
The
law?
question of law left open vis-a-vis the Honorable Supreme Court. My lords, the question of law has been left open for the Supreme Court to consider in some other case. But as far as the Honorable High Court is concerned, that is the law that binds until it is interfered with by way of a subsequent judgment. Because,
So,
my lords, first,
so in this regard, whatever that is to be challenged, that is to be challenged in the SLP only. Not
no, my lords,
It
my
court
lords,
or before the
my lords,
appellate.
I'll submit, my lords, what has happened, if at all, an issue has to present itself. As far as any high court is concerned, my lords, other high courts, it is only persuasive.
Mr.
Yes,
I
my lords.
appreciate
Yes,
your submission. Yes, the point raised by the petitioner in the appeal that has been dismissed and that has been upheld by the Supreme Court. I totally agreed with that. Okay,
Indeed,
this cannot go into that. Okay, I appreciate to that effect. But once the paragraph 3 has come, however, the question of law is kept open. If it is kept open, so this court and the division bench have hands are tied, so we cannot decide the issue
Well,
further.
let's- in my humble submission, that is the law.
Okay.
In my humble submission, that is the law. Once the Supreme Court under 136 has refused to interfere, then the doctrine of merger does not apply. The judgment stands undisturbed and its presidential value has not been robbed. But the occasion
that's what. So what about the paragraph 3? Who will decide the issue? Kept
Well,
open,
let's-
kept open
that
question.
has to be decided by the Honorable Supreme Court. It's been left open for the sake of the Honorable Supreme Court.
Under in which application?
Any time, Millets, a similar
That's
issue
what
comes
we-
before it, it will decide that one.
Or a
As far
larger
as the High Court is concerned, Millets, as far as the High Court, Millets, it's the usual practice in Supreme Court. It's the usual practice in Supreme Court that we all mention. If the Supreme Court is not with us,
With regard to division bench order, Supreme Court order, dismissal, there is no ambiguity.
Absolutely.
yes,
There is no
Millets.
ambiguity.
Yes.
Yes,
But
Millets.
now the paragraph 3, the question of law is to be
Kept
kept
open.
open. If it is kept open, to whom? Only to the Supreme Court, and Supreme Court already dismissed, so they cannot.
No, in a subsequent
What's
matter,
been said, Millets? Millets, what's
a
been
larger
said?
bench of the Calcutta High
My
Court.
lords may kindly see what's been said, why they have not examined first paragraph, my lords could see. Though the petitioner has raised some substantial question of law, which might require consideration, however, keeping in view the election schedule in the state,
Correct.
they have said this is not a fit case to examine that one. So we are not interfering with the judgment and that judgment remains.
Okay.
When the occasion comes, we may examine. That's how the option has been.
Okay.
That's why, my lords,
Then the other
judgment-
way around, DB
Right.
judgment stays.
That stays, absolutely. This is my humble submission, Millets. So that has not been diluted. That's not been diluted. Even a co-equal division bench is bound by the judgment. That's what my lords have had many a time when it comes to certainty, judicial discipline, these things, other ones. Now let me come to the statutory parameters, Millets.
Yes.
Could my lords take, Millets, the Representation of People Act 1951?
And you will not adhere to. Huh? Huh? তবে senior ground question অন্য
Yes.
ওটাও চলে যেতে পারে।
Which section?
Let's kindly come to 1951 Act, Section 19, capital A.
Section 19,
A, capital A, Millets.
capital A, yes.
Delegation of functions of Election Commission.
Yes.
The functions of the Election Commission under the Constitution, the Representation of the People Act 1950, and this Act, or under the rules made thereunder, may, subject to such general or special directions, if any, as may be given by the Election Commission in this behalf, be performed also by a Deputy Election Commissioner or by the Secretary to the Election Commission. This, my lords, have seen the power of delegation as far as the other authorities are concerned. Now let me come to Miller's section 20, capital B.
Yes.
Before that, may I just take your lordship to section 20 as well. 20. General duties of chief electoral officers.
Yes.
Subject to the superintendent's direction, my lords got it,
Yes.
direction and control of the chief electoral officer, the district election officer shall coordinate and supervise all work in the district or in the area within whose jurisdiction in connection with the conduct of all elections to parliament and the legislature of the state. The district election officer shall also perform such other functions as may be entrusted to him by the election commission and the chief electoral officer. Now let me come to 20B, Miller's observers.
Yes.
The election commission may nominate an observer who shall be an officer of government to watch the conduct of election or elections in a constituency or a group of constituencies and to perform such other functions as may be entrusted to him by the election commission. The observer nominated under subsection 1 shall have the power to direct the returning officer for the constituency or for any of the constituencies for which he has been nominated to stop the counting of votes at any time before the declaration of the result or not to declare the result if, in the opinion of the observer, booth capturing has taken place at a large number of polling stations or at places fixed for the poll or counting of votes or any ballot papers used at a polling station or at a place fixed for the poll and are unlawfully taken out of the custody of the returning officer or are accidentally or intentionally destroyed or lost or are damaged or tampered with to such an extent that the result of the poll at that polling station or place cannot be ascertained. My lords, see subsection 3, where an observer has directed the returning officer under this section to stop counting of votes or not to declare the result, the observer shall forthwith report the matter to the election commission, and thereupon the election commission shall, after taking all material circumstances into account, issue appropriate directions under section 58A or section 64A or section 66. Explanation. For the purpose of subsection 2 and subsection 3, observer shall include a regional commissioner or any such officer of the election commission as has been assigned under this section the duty of watching the conduct of election or elections in a constituency or group of constituencies by the commission. In fact, Millers, even the Election Commission of India staff could be the observers, and this is the sweeping power that's been conferred on the election commission and its discretion, Millers. This is how. Now, Millers, my lords, have also asked a pertinent question with regard to the bar under, I'm just coming to that one, Millers, 329B. Millers, it's been many a time referred to your lordships, put before your lordships' kind consideration. Now let me take section 100 of the same act. Section 100.
100 of?
RP Act 1951, Millers.
Yes.
Could my lord see, Millers? Grounds for declaring elections to be void.
Yes.
Subsection 1, subject to the provisions of subsection 2 of the High Court. The High Court is of the opinion. My lords could see D. D. Kindly see D, Millers. That the result of the election, insofar as it concerns a returned candidate, has been materially affected.
Correct.
Next, Millers, kindly come to clause 4.
Yes.
By the non-compliance with the provisions of the Constitution or of this Act or of any rules or orders made under this Act.
Correct.
That's why, Millers, if anybody has any grievance that Election Commission has not followed the rules and it has conducted itself in holding the elections or the counting, whichever element of, my lords have seen many a constitution bench of the Supreme Court has said election should be expansively interpreted from the date of notification till the declaration of results. It should be read as election. That's what M.S. Gill has said and many other judgments have said. Now, Millers, my lords may kindly see, this is one election dispute that could be raised. That's why squarely 329B attracts. Then the second aspect, my lords may kindly see, this very notification was issued on 13th April 2026.
Yes.
And it was in the public domain.
Yes.
Millers, had there been any grievance on the part of any person, it would have been challenged on time. And they're feigning ignorance. Millers, in every other case, even before the ink could dry, on interdepartmental or intra-departmental, very confidential communication, they could place it before the Honorable Court within a couple of hours and agitate saying that one. You could never question how I got that one. You only have to say whether that is correct or not. This is what they plea all along. Now, for the first time, they feign ignorance and say, I come to know about this one very recently. The logic is simple, Millets. Monday is the election. Today, if there could be an introduction, Millets, we cannot have the composition again set right. Then essentially counting could not take place. Then that results in postponing of the whole process. That's how 329B comes into picture. Millets, when it comes to conducting of elections, Millets, my lords have said, even when an MRO office was shifted by the government, somebody questioned, no, that should have not been the Panchayat office, to be precise. That is not the suitable place. This is the place. Court said that they have enjoyed the power under Article 162, and then they have got the coextensive power with the legislature. Then how could you dictate every term? That's why they have just thrashed it out. Here at my lords may kindly similars, they wanted to breathe behind the neck of the Election Commission, saying that, no, you should not stand, you should not sit, and you should just conduct elections as I please. And they could not succeed. My lords may kindly appreciate, last 3-4 months, ever since the SIR has begun, dozens of applications, dozens of petitions have been filed before the Honorable Supreme Court, including with regard to returning officers, including micro-observers. They could not succeed anywhere. Then, Millets, they have gone before the Honorable High Court of Calcutta. There, they have raised all these pleas in a PIL. Again, they have lost. And now their only fig leaf is that, Millets, since the question of law has been left open, I can re-agitate. Kindly visualize, Millets, the mammoth task that's been there before the Election Commission. And then, with no time, if at all, Millets, I need to contradict, I need to place my material, Millets, I need to have my counter put in place. I may be requesting your lordship for reasonable time to come back with my defense, and that has to be placed. Then your lordship may do that, something on the merits, whichever way, Millets. Then either party could have their remedy with regard to any aggrieved, if they are aggrieved, Millets. Now, my lords may kindly see, every time.
That's why a specific question was put to you with regard to
Yes,
the paragraph 3. If you are telling that if this court will give time to file affidavit on all these things, if this court will give time to file an affidavit, so what the question? It is up to the Supreme Court. So what purpose would be served by keeping the writ petition pending?
Yes, Millets. Millets, but the difficulty is this, Millets.
That's why you're telling that you will bring all the things on record. If you bring all the things on record, and this court will not able to pass an order because the matter is kept by the Supreme Court only. So what this court will do?
Millets, I submit, it's been there for a while. The date I mentioned, Millets, 13-4. If they wanted a remedy, they could have come on time. They have not done that one. They have chosen this time. And Millets, in this case, my lords have asked what is the value of the question of law left open, Millets. What's the judgment this is? 22 of which judgment? One moment, Millets, I may be kindly forgiven.
When I want to cite a judgment.
Please.
If Mr. Naidu doesn't cite.
Millets, this is Millets. 2024 SCC Online Delhi. Could my lords kindly, this is a division bench judgment, Millets. 2024 SCC Online Delhi 8805.
44?
Millets, one moment, Millets. This is page number 8805. I may be pardoned, Millets. 2024 SCC Online Delhi 8805. My lords got it, Millets?
Yes.
Let me read the proposition. In this one, Millets, para 22. Para 22 of this judgment, Millets.
Yes.
On the presidential value of the judgment of the High Court, when the civil appeal preferred thereagainst is dismissed by the Supreme Court, leaving the question of law open. This court had an occasion to observe recently in SSC versus Darpan Sharma as under. On the implication of a question of law being left open by the Supreme Court while dismissing an appeal or a special petition, a division bench of the Honorable High Court of Gujarat in Collector so-and-so ruled as under. When the Supreme Court records that the question of law is kept open, undoubtedly it's meant to be considered in future by the Supreme Court only. The question of law, as correctly contended by Sri so-and-so, is not kept open for the High Court.
Okay.
This is precisely what was held and observed by the division bench of this court in an unreported decision in so-and-so, where in full agreement with the view expressed therein, it was a case where an issue so-and-so. Millets, this is what the law in my humble submission.
Thank you for that.
I am grateful, Millets. I am grateful for the opportunity.
If Mr. Naidu is finished.
That's Mr. Anything further, Mr. Naidu?
I've read it. No. I've read 20. Yes. I beg your lordship's pardon, but I'm getting instructions because I've just been briefed just a while ago.
Further? Any further submission?
I think my friend will supplement Millets.
Let's have one judgment.
Millets, I'm grateful for the opportunity. I thought Millets it was curtains yesterday, not to be so.
The reason I stopped is A, my learned friend is senior to me. B, I don't want to waste the time of the court. So if there's something which he wants to say, I shouldn't repeat it. Lord, please have a look at this judgment. This is what I got a copy. Lord, have I handed up Lord, multiple copies to your lordship? No,
I
I'm
have
sorry, Lord. This is 1982, volume 2 SCC, page 218.
yes.
Lord, please have a look at the first paragraph. The transferred case and the appeals connected with it raise important questions. Which
Paragraph?
Paragraph 1, Millard. The transferred case and the appeals connected with it raise important questions which require a careful and dispassionate consideration. Hearing of these matters was such and such. Judgment will take some time. We propose to state our conclusion on some of the points involved. Now, please see one. High Court acted within jurisdiction entertaining writ petition and issuing a rule nisi because since the petition questioned the vires of the law of election, but with respect, it was not justified in passing the interim orders dated such and such and in confirming those orders by its judgment dated such and such. Firstly, the High Court had no material before it to warrant the passing of those orders. The allegations in the writ petition are of a vague and general nature on the basis of which no relief could be granted. Secondly, though the High Court did not lack the jurisdiction to entertain the writ petition and to issue appropriate directions therein, no High Court in the exercise of its powers under Article 226 of the Constitution should pass any orders, interim or otherwise, which has the tendency or effect of postponing an elections which is reasonably imminent and in nature and in relation to which its writ jurisdiction is invoked. The imminence of the electoral process is a factor which must guide and govern the passing of orders in the exercise of the High Court's writ jurisdiction. The more imminent such process, the greater ought to be the reluctance of the High Court to do anything or direct anything to be done which will postpone that process indefinitely by creating a situation in which the government of a state cannot be carried on in accordance with the provisions of the Constitution. India is an oasis of democracy, a fact of contemporary history, which demands of the courts the use of wide statesmanship in the exercise of their extraordinary powers under the Constitution. The High Courts must observe a self-imposed limitation on their powers to act under Article 226 by refusing to pass orders or give directions which will inevitably result in an indefinite postponement of elections to legislative bodies, which are the very essence of the democratic foundation and functioning of our Constitution. That limitation ought to be observed irrespective of the fact whether the preparation and publication of electoral rolls are part of the process of election within the meaning of Article 329B of the Constitution. We will pronounce upon that question later on. Then, my lord, paragraph 2, the second paragraph. It takes years to build up public confidence in the functioning of constitutional institutions, and a single court hearing perhaps to sully their image by casting aspersions upon them. It is the duty of the courts to protect and preserve the integrity of all constitutional institutions which are devised to foster democracy. And when the method of their functioning in question, which it is open to the citizen to do, courts must examine the allegations with more than ordinary care. The presumption, be it remembered, is always the existence of bona fides in the discharge of constitutional and statutory functions. Until that presumption is displaced, it is not just or proper to act on preconceived notions and to prevent public authorities from discharging functions which are clothed upon them. We hope and trust that the charges leveled by the petitioners against the Election Commission, the Chief Electoral Officer, and the Electoral Registration Officers will not generate a feeling in the minds of the public that the elections held hitherto in our country over the past 30 years under the superintendent's direction and control of successive election commissions have been a pretense and a facade. The public ought not to carry any such impression, and the voters must go to the ballot box undeterred by the sense of frustration which the petitioner's charges are likely to create in their minds. We see no substance in the accusation that the voters list have been rigged by the election authorities with the help of enumerators belonging to any particular political party. Enumerators are mostly drawn from amongst teachers and government servants, and it is difficult to imagine that 35 years after independence, they are totally colorblind. They are the same in every state and every constituency. The safeguard lies in the efficiency and impartiality of the higher officers who have to decide objections for voters lists, etc. So, my lord, this also went from Calcutta. The writ petition was dismissed.
Yes.
Now, my lord, just one sentence regarding the judgment, my lord. One paragraph I wanted to show from this judgment. My learned friend, my lord, relied on the next paragraph. My lord, please take page 14 of the judgment. Oh, I'm sorry, my lord. My lord, page 21, paragraph 38.
Yes.
Lord, paragraph 38 is identical to the situation before your lordship. Petitioner has not disputed existence of power with ECI. Here also, he is not disputing the existence of power to appoint central government employees. His argument is that no, you also should have employed state government. Leave the ECI to do that, to do their job. The presumption is they are doing it correctly. And the fact situation is they're doing it well. There's been unprecedented voting. Now, my lord, next paragraph. In the writ petition, the petitioner needs to plead and prove his case. Here, my lord, there is no pleading. There is surmise that, my lord, central government employees will, my lord, do something wrong. He has to prove his case. Now, my lord, I'll very quickly, my lord, point out some judgments to your lordship from the compilation, which I will refrain from reading in great detail because they've been read before your lordship, my lord, multiple times over the last few days. But I just take names of the judgments and, my lord, stop. My lord, on the my lord, copy down. What is this? My lord, I'm sorry, I should have. Didn't strike me. This is what I cited earlier, and this is the compilation.
Thank you. The compilation is to division.
And we will change জিনিসটা নিয়ে ঘুরে বেড়াই।
All that judgments are distinct.
Yes, that's why I am not wasting court's time. My lord, please, my lord, take, my lord, I'm citing, my lord.
কম্পাইলেশনটা দিয়ে দিয়েছি প্যারাগ্রাফ গুলো করে দিই
হ্যাঁ, তাই এখানে আছে তো।
তুই একটা শেষ করবি না?
এক্ষুনি করবি।
না তুই তোর স্ট্র্যাটেজি কি শেষ করবি?
I have no strategy.
No,
My lord,
when Mr. Chaudhary has been engaged by the election commission, so he thought that this court should be continue till 5 o'clock.
no. It's only 10 past 10. I'll take just 1 minute, my
I
lord.
like him in the dining table. I don't like these things in the hair.
Yes,
He is a very good.
my lord, my lord,
He selects the menu very nice.
my lord, I'll tell you, lordship, at the end of the day, Mr. Bandopadhyay is a senior I've worked with for 20 years plus, and I've really enjoyed working with him. We've had some brilliant times in Delhi doing company matters. And one day, my lord, we'll both tell your lordship the experience
Sometimes
outside, but only one sentence. I take pride and joy in being the first person to introduce to cod, which is a wonderful fish.
Oh,
Yes.
If my lords forgive me, millets, only one sentence I'll add with my lords kind leave, millets.
Yes.
Yes, we were caught off guard, millets. We have to fish for something and place before your lordships, as my learned friend has correctly said, millets, a constitutional institution that enjoys presumption of correctness and something has to be hurled it. There should be some basis, millets. For that purpose, what's been said by the Honorable Supreme Court way back in 1982, millets, the judgment is 1982 2 SCC 218.
1982? Yes,
So
yes.
that's the one I
Millets,
read.
1982 2 SCC 218. My friend must have just
That-
once, since my lords could see, millets.
I read it.
Kindly,
I also
Parrot-
saw. I'm sorry. I'm sorry,
beg your
Mr.
pardon.
Please continue.
Yes, my lords, kindly come to para 2, my lords, in the judgment. We are unable to accept the argument advanced on behalf of the petitioners. My lords could see, my lords.
Yes.
We are unable to accept the argument advanced on behalf of the petitioners that the Election Commission or the Chief Electoral Officer or the Electoral Registration Officer have in any manner acted in violation of the Constitution, etc. The second paragraph, my lords could see. It takes years to build up public confidence in the functioning of constitutional institutions. My lords got it?
You take a note of it. Mr. Chaudhary has
Yes,
already.
and my lords, and also that above paragraph, my lords, para 1, subparagraph 1, it's been said, the imminence of elections must also be a factor to be taken note of once the Honorable High Court is exercising its powers under Article 226. It's not a question of imminence, my lords, in my humble submission. It's the middle of elections, and elections are over.
Thank you.
And my lord, now they would like to upset the apple cart, my lords. That may not be permissible. And my lords have seen the scope of 329B, my lords, which has been said. And my lords, I'm not troubling your lordships. We have already had a compilation with regard to 329B that will be handed over to your lordships, my lords, with paragraphs marked. Grateful.
One sentence. This is directly election. Number one. Number two, last minute Article 226 order would have the effect of actually preventing elections from concluding. And that's all, my lord. I stop there.
Yes.
Lord, first of all, my learned friend's submission. I do not want to tell that he has opened his mouth, therefore I have to speak. First of all, submission is that the vague. Correct? Kindly come to page 27. Which order is challenged? I have read it, but sorry, my lord, I am just.
Yes, no problem.
In view of the apprehensions, he said, writ petition is on the basis of the apprehension. Apprehension is the basis of the order of the impugned. And from various quarters regarding possible irregularities. What that possible, my lord, the quarters regarding possible? 1 hour, the argument has been made by the Election Commission. They could not produce a single document. From whom? Therefore, this 45, my lord, my statement made in paragraph 8. You are working for only one group, one political party. Can you read paragraph 8?
Yes.
Everything is vague. The foundation of the order is vague. Give the details. His case is that I am apprehending. Therefore, writ petition is liable to be dismissed. Therefore, he is on the apprehension. Therefore, order should be set aside.
Yes.
And you are conducting election. Nobody. You are conducting election. You are saying that votes are with a view to ensure transparency and orderly conduct of counting process.
Yes.
Now, my second submission is, the returning officer handbook is not with us. What you have given to the candidates handbook. Returning officer, it is yours. Returning officer, it is yours. Handbook of the to the candidates, that is for everyone. Now, what you have written, that is not written in your drawer. It is there or not. That is not the. I am not required to sue. Even then, when he has relied upon, returning officer. হ্যাঁ দাও একটা আমাকে দিয়ে দাও, এটা আমি নিয়ে চলে যাবো। না পাওয়া যায় কেন, তোদের অফিসে পাওয়া যায়, আদৌ আমাদের কাউকে দেয় না এটা। আমাকে কেউ ভালোবেসে দেয় সেটা অন্য কথা, আদেশ পাওয়া যায় না। দেখি কোন প্যাকেট কোনটা রাখালি। হ্যাঁ, নাও সি 15.7.9.
Yes.
Counting staff appointment should be made in the form given in Annex 35. Counting supervisors should be preferably by gazetted officer Group B or above, comma. Counting assistants should also be Group B or at least Group C officials of the central or state government. Therefore, only the counting assistant has been allowed, not others.
No, first line, the counting supervisor.
Counting staff appointment should be made in the form given in Annex 30. Stop. Counting supervisors should be preferably be gazetted officers Group B or above, comma.
Counting assistant.
Counting assistants should be also be Group B or at least Group C officials of the central or state government or officers of cooperative.
Of the central and state government.
But this is only case of a counting assistants.
No, comma. Counting supervisor.
Comma, counting assistants. Counting assistant, not the others.
Okay.
Not the others.
Yes.
Right? Now, my lord, see, it has been said above the judgment earlier. What was the challenge in the? It was not touching with the counting. What was challenged in that? They have not said so. He was reading the judgment, taken 15 minutes to read the judgment. What was the challenge? Challenge after the transfer of the returning officer. Returning officers were transferred. Police officers were transferred. That was under challenge. That was under challenge. Here, counting has not been taken place. That time when the process of appointment of the returning officers had been done, that order was challenged.
Yes.
Police observers' appointments were challenged. Already appointed and they are working on.
Correct.
Counting has not yet been taken place. And there is, indeed, during election, no holidays. Whether it's Saturday, Sunday, Monday, nothing.
Yes.
Nothing. Second, my lord, kindly see. Last, my lord, third, not last. Do you see? I want to hear this argument from Mr. Naidu in Supreme Court. Not here. You will.
My friend and me, we always meet in Supreme Court, and he's welcome once again.
This is the argument I want to hear, that only Supreme Court only hear the point of law, not any other court. Let him speak of that.
Yes.
This argument that this point of law only will be asked in the Supreme Court. I wish to hear this argument from him in the Supreme Court. Now, though through the petitioner has raised, a substantial question of law, which might require consider, however, keeping in view the election schedule in the state, we are not inclined to entertain the special petition. The special petition, however, the question of law is kept open. Although there's, see, the question of law is kept open. To whom to decide? To whom this can be decided by any appropriate court.
Yes.
Therefore, the merger issue, etc., doesn't arise here. If it is a plain simple dismissal of the writ petition, a SLP, then I can understand. And see, why did not interfere? Because already schedule is there. If schedule is there, why the change of game, policy of game in the midst of schedule? See when the order was passed, according to the, although we have got it, 13th April, notification was 7th or 9th March.
Correct.
7th or 9th March, whatever the law was there, whatever is there, already nomination has been completed.
7th March only notification.
Before 16th April,
16th
13th April.
Yes. That
Nomination completed by 9th April.
correct.
Why you are changing the rule of game? It is not an action, it's a policy decision. How can you do it?
Yes.
Why my petition was not accepted? Because schedule has been declared. Right?
Yes.
If the schedule has been declared, why this memo? How can you change it?
Yes.
But the question is not that the appointments have been made. Question is it illegal?
Okay.
Whether whatever the phase you have, whatever the consequences may be, it is not a matter that one day you can appoint it. After the election, it is not you are enjoying holidays in your home. Give a declaration that no, from today after 5 o'clock, nobody will work. Give it. The problem is that, I am a man of the field. I am a man of the field. Now, he said that the superintendent power of the Supreme Court, power of election commission should be respected, etc. In West Bengal cases, power of Supreme Court, power of election commission has been curtailed. Lordship knows that orders have come to your lordships. That first adjudication will be done by the judges. This is the power of the election. Why Supreme Court has done it? Then appeal tribunal has been made. Of course, that is a 30 years. We have now 75 years and 78 years. When we have come across these so many cases, then the Supreme Court is curtailing the power. He has shown these judgments.
Well, it's your lordships have always appreciated
No,
one
no,
thing.
Mr. Naidu, don't
That-
interfere. No,
Mr. Bandyopadhyaya, just wait, just wait. You
No,
have
no.
lung power. I have
No,
also
no,
equal lung power. Don't try to calm me down. If you are
Finding
making
the
political
problem
speeches, if you are making political speeches,
No,
do you
no, you
expect to be
you are-
quiet?
Mr.
you are
Naidu,
See,
directly.
if you have merit, if you have merit, confine to the
No,
matter and impress the honorable court.
Mr. Naidu.
If you have merit,
First, can you see?
confine to the facts, and you are using even the honorable Supreme Court, where you could not succeed in one instance, and you are making all these tall claims. Please, this is high time somebody call this bogey out.
Doing this.
Mr.
Don't
Naidu,
think that you
please,
can
please,
get away with
please.
everything. Don't think you can get away with everything. If
Mr.
it's-
Naidu, you are
You
in
use
the
every institution, including the courts, to say that one.
you
please
have lost
confine
this
the
compared
facts.
to 3 years.
Please
3 years.
confine to the facts.
I
If you have
don't
merits, please impress the honorable
Yes,
court.
yes, I am on merit.
Instead of indulging in this character
But not merit,
assassination.
you don't understand
And
which is
that
merit and which is not
specialization,
merit.
I don't want to have.
Yes, you don't
Yes,
get it.
please,
Now,
if you have merits, please argue that matter.
disturbing.
Calling everybody names, it serves
Mr.
no
Naidu,
purpose.
Mr. Naidu, please let it
Well,
complete.
your lordships have seen, have we uttered even one word extra beyond the brief?
No. Yes.
Don't say extra on the briefs. Don't advise.
Yes, yes.
Yes, don't advise. Again,
Mr. Bandyopadhyaya, your
Yes.
frustration is writ large. That shows
Yes,
your
your frustration, I can
helplessness.
understand your
That
frustration.
shows your
The power
helplessness.
has been taken.
I only- I only
Election Commission has done everything.
I only
understand your
sympathize with
frustration.
you.
I
I only
understand your
sympathize
frustration.
with you.
You
When
are very disturbing.
exposed,
Sorry, I have to say now.
yes, when exposed, only the rhetoric is your answer. Please go ahead.
Yes, continue.
Now that everything has gone in from my mind. He is in the habit of disturbing.
You are the senior.
no, what
You
is-
knows what
what
the,
is-
what the
what-
opposition.
He was a judge of a high court. See,
Yes.
now my lord, public confidence, who will judge? Election Commission will judge. When seriously Election Commission's power has been questioned on number of occasions, and your lordship has seen that the Supreme Court has said serious questions of law has been raised.
Yes.
Now my lord, see, the আর কি কি ছিল যেন একটা এতক্ষণ বলেছে না এটা রেখে দে দরকার আছে আমার। এটা দিস না, পরে না এরকম করিস না, দিয়ে নিতে নেই, দিয়ে নিলে না না এটা দিয়ে নিলে কালীঘাটে দিয়ে নিলে কালীঘাটের কুকুর হয়, দিয়ে নিতে নেই। There is a proverb in Bengali. If you give and if you take, then you will be dog of Kalighat. Don't do it. Now, just one.
My dog has the best life.
Yes, I have one German Shepherd. Beautiful. But kindly take 2000. এটা কেন দিলেন? ওইটা আগেরটা দিতে বললাম তো, এটা আগেরটা দেখাতে বললাম তো। আরে ভাই তোমরা কেন?
কখনই খাবি কিন্তু।
No, just আরে ভাই এটা না 84. Just 1 minute, will just one. ওই দোষিস 84টা দিতে বললাম, যেটা তুমি দেখালে যে 1983 ধর ভাই তুমি কি পাগল হয়ে গেছো নাকি? এই জাজমেন্টটা কোথায় দিলি রে বাবা? তুই আমাদের ডিভিশন বেঞ্চে দেবো।
আমি দিচ্ছি, বলুন না।
ডিভিশন বেঞ্চে জাজমেন্ট একটু দিলাম।
হ্যাঁ।
পাগল আছে নাকি সব? আরে তুমি প্লিজ সিট ডাউন। Just 1 minute. AC Jose versus Sivan Pillai. 1984 2 AC 656. বার করো।
না এটা না।
এইমাত্র তো বার করেছিল তো, যেখানে দাগ দিলে সাইডে দাগ আছে তোমাদের। হ্যাঁ? দাও দাও। আর 84 এটা দাও। Now can you take this one? Can you take this one? 2024 volume 18 SCC page 643. কোনখানটা? কোনখানটা যেন দাগ দিয়েছিল? Yes. Kindly come to me, Lord. Yes. Kindly come to me, Lord. Paragraph 37. 36. Kindly see. All judgments have been considered. Mind this seal gives. Okay, just a work. So and so. All judgments have been considered. Right? Now, kindly read below paragraph 37. We would indicate that the restraint self-imposed by the courts as a general principle laid out in some details in some of the decisions. Supra in election matters to the extent that once a notification issue and the election process starts, the Constitutional Court under normal circumstances are loath to interfere is not a contentious issue. But where issues crop up, including unjust executive action or an unjust or an attempt to disturb a level playing field between candidates and political parties with no justifiable or intelligible basis, the constitutional courts are required, nay, they are duty bound to step in. The courts have usually maintained so and so.
Yes.
Talking about political, now my lord kindly see that judgment paragraph bar kor ekটু আগে বার করেছিল now 1984 2 SCC my lord law জজকে দাও 84 2 SCC 656 AC Judge Miller spoke about the scope of the writ court. It is I am not stopping an election. দাও জজকে দাও I am handing it over, just I am reading. The
You give the what are the paragraphs?
paragraph 22. Now you have come into with the procedure of law. You have come with the procedure of law. Now how can you commit a breach of that? Now, my lord, kindly see what is the answer. No answer has been given to this paragraph, particular paragraph. I have said so. Where is the petition? Petition. See, what is the answer? Paragraph 16.
Yes.
Except in state of West Bengal, no answer has been given by them. Now, beloved, very recently, they issued an order regarding the, beloved, what has happened in that matter first. The circular I just said, Dennis' judgment. Beloved, what has happened? They issued a circular, said this 800 people, giving all the names of the persons, right from Kuchbihar to Purulia, all are belong to Trinamool Congress. They should be arrested. And High Court has passed an order. They are also, Mr. Naidu sought for time for affidavit. First, the court has recorded the Honorable Chief Justice and granted stay. Well, kindly, this is a big order, and your lordships will find that he has said that he is asking for time to file an affidavit. Time for filing an affidavit is no ground for refusal of an interim order.
Yes.
This is 13, paragraph number 13. The High Court has stayed the order. This is judgment order. Interim order. High Court has stayed this order. Division bench has stayed this order.
WPA.
Now, I just very interestingly I tell you, your lordship, WPA P 192 of 2026.
190.
192. Now, what has happened, my lord?
Date.
Dated 22nd April 2026. Stayed the order. Now, my lord, what has happened? Thereafter, before 27th April, this election was there. 29th April. 27th April, my lord, they issued another circular giving 4,000 people's names of the All India Trinamool Congress. This election commission in India. How can I have a trust on them? Fortunately, that time the persons were someone's. This time now others. Now, when urgent mentioning was done, matter was fixed at 2 p.m. 2 p.m. they have come up with a circular, we are withdrawing. হ্যাঁ, withdrawing on that day, ভাই তুমি তোমার পকেটের মধ্যে কি রাখছো আমার দেখার দরকার নেই। Whatever you are keeping on your pocket, I don't. They have shown it in the court. See, my lord, on how many occasions I have to come into the court. They are saying how they are coming, and every occasions I have come to the court, I have got the relief. First relief is
This self-certification leads us nowhere. Let him, Millets, with great
must-
respect, confine to the pleadings of the
you have
case.
built up. No,
And
you
he wants to impress upon your lordships, unfortunately, falsely, that every time I've come, I've got the relief. This time also I should. And may I say, Millets, every time he came, he lost.
he said that
Miserably, he lost. He
They
presents
said
a
that-
pathetic picture.
they said
And wants
that
to self-glorify himself. He wants to
number-
self-glorify himself. He wants to give certificates to himself. Millets, with all your lordships' long experience, Millets, and your lordship seen a rejoinder, a reply argument
I don't
going
know.
on eternally and ad nauseum.
Mr. Chaudhary.
just 1 minute.
Just because my lords feel that, okay, let him, it goes on.
Well, kindly see, my stand, which was from the initial day to this day, is power of superintendence is there rested with the election commission. Directions can be issued by them. If it violates any law made under Article 327, that is bad. When you have laid down the procedure, you can't deviate from the procedure. This is the case.
Okay.
You can't change the procedure. In case of one state, one procedure, another case is another state. And my lord, yes, the power which was telling, my lord, this represents the people's.
There's no deviation from procedure. I've shown you a lot.
Mr. Chaudhary,
We
you
can
are
trace all the material millets. We have been uniform in every state. We have not singled out anyone.
But he's giving no advice. Where is the
That's why millets, they come at the 11th hour so that we cannot show to your lordships.
what is this? Election commission is perturbed.
Okay.
You will kindly see, you will be more perturbed on 4th.
কি আছে তাড়াতাড়ি?
সেকশনটা কত দেখাচ্ছিল জানো? সেকশন গুলো দেখাচ্ছিল না, লিখছিলেন?
100.
No, not 100. 100 is the the election dispute.
Yes.
Regarding the delegation of powers.
That 19A.
19A, kindly see
19A, 20.
19A, delegation of functions, the functions of the election commission under the constitution of the act under the rules are made there as may be discretion of the secretary, not the assistant chief election commissioner who has passed the impugned order. Then see, generally it's subject to the superintendent, subject to directions, control election commission, the chief election officer shall supervise the conduct of elections in the states under the act. Supervise the election. That doesn't mean he will lay down the policy decision. This power is vested with the chief election commissioner, election commission, or the persons whose names are there in section 19A.
Yes.
Then will have general duties of district election officer. CO is not the district election officer. Then observers. It is not questioning about any functions of the observers. Counting superintendent is no way it can be equated with the observers.
Yes.
One judgment I am missing, I am remembering, that is 82 or 83. The Supreme Court has said, you see, I'm forgotten just the principle of law I am saying, Millard. You see, if there is a case to pass an interim order, court will pass an interim order. Court will not look into the consequences of that. Question is, Millard, whether I have pointed out any illegalities or not. If I have pointed out illegalities, your lordship will pass the order. If I am not.
Okay.
These are the.
Your lordship had a question for me,
Yes.
Milord?
This 13th April, which is under challenge.
Yes.
Correct. You have issued on the apprehension. What is the main issue raised by Mr. Banerjee?
Yes, Milord.
So you are also having the apprehension. How it can be?
I'm sorry, I didn't hear the question.
Kindly see the first line. In
Yes.
view of the apprehension.
In view of apprehensions expressed from various.
Can I go, Millard? I have to. Incidentally, I have to go to a one returning officer now.
Yes.
And I have failed. I know everything. So chief election commissioner is a bhalo election.
তা বুঝবেন তো। Of course.
And you know his client what he said, requested me. Dada, you please be a counsel of us. Ask him.
Would have been a better counsel than me for sure.
Okay.
Milord, yes, Milord.
The apprehension
Page
expressed.
27, my lord.
Page
In
27.
view of apprehensions expressed from various quarters regarding possible irregularities during the process of counting of votes,
Correct.
and with a view to ensuring transparency, integrity, and orderly.
That is okay. That is not-
Yes,
So you have issued this order on the apprehension.
yes.
Correct. And if
No.
you have issued the apprehension, now you come to the paragraph 16 of the writ petition. Can
Yes.
you have issued the same order to the Assam, Kerala, Tamil Nadu, Pondicherry?
Paragraph 16
Paragraph 16.
is unaware as to whether any similar notification.
These are the two issues which Mr.
Yes.
Banerjee has emphasis
Yes.
on that.
My lords, my instruction is we have done that in Kerala.
Okay.
We have done that one in Kerala, my lords, not singled out any state for that matter. As the situation demands, my lords, we do that one. And also, my lords, the question is, my lords, the powers of chief electoral officer, and section 20 is loud and clear on that aspect, my lords.
No, that
Section
you
20. My lords, I have already taken note of that one. I would like to tell, my lords.
but even again, then how the election additional chief electoral officer can come?
My lords,
Can
within
you
the state, there are
can you-
delegation of powers, my lords.
Can you come to the
Within the
19
sphere, there are delegation of powers.
Yeah, can you
And
come-
based on that one, my lords, it is not their case, it is the question of vires, in my humble submission.
Yes, not virus. What he is telling.
Yes,
that-
my lords.
These are the main 3 points Mr. Banerjee has taken into consideration with regard to the apprehension, with regard to the other 3 states, and the additional chief electoral officer. What?
They say, my lords, nobody has the power. 2023, we have put that in the public domain. Para 15
Okay.
plus 9, that these are the powers that could be exercised when the situation demands.
Thank you.
Grateful, my lords, deeply obliged.
Thank you. Thank
There's another supplementary.
you. और क्या चाहो तो समरी नहीं
Yes, yes.
और क्या अच्छा एक भी डॉक्यूमेंट इधर ये उनको दे दो पहले एक भी डॉक्यूमेंट इधर उधर जजमेंट इधर उधर नहीं जाना उसमें देखो एक नोट लिखा होगा
My lord, the observer's handbook, my lord. I had
Yes,
brought
we
a
will-
copy. Copy is down. Here, Anna. My lord, they have it. We've also, my lord, given them soft copies.
Yes,
But if they give it, I
yes, what is
think.
the next matter
And the next matter is at the instance.
एक साथ क्यों नहीं निकलता आप लोग?
Just, my lord, we'll print in.
Instruction nothing to be done.
Leave was obtained in the morning.
He obtained only one file has come, one list has been published.
My matter is
How the second list has been published without the instruction
I
of
do
the
not
court?
know, my matter is earlier at point of time.
I don't know.
Kindly see the WP number.
I don't know.
It is not anyone's fault. Maybe the system has listing.
Going on, I don't know. Yes, what is the matter?
This is at the instance of the candidate belonging to one political party.
What is your prayer? sir?
My prayer is last moment change of counting venue. Counting venue. This entire law flows from Rule 51.
Where is the order? Where is the impugn
Yes.
order?
Kindly see at page 108. Please.
Yes.
Please see page 108.
Hmm.
Convening of meeting in connection with general elections to the West Bengal Legislative Assembly 2026. This is dated 26/4/2026 in pursuance of the directions of the Election Commission of India. And in view of the forthcoming general elections to the West Bengal Legislative Assembly, an urgent meeting with all candidates will be held at 6 p.m. at Gitanjali Stadium, such and such, for the smooth conduct of the electoral process. This is dated 26/4. The date of meeting is 27/4/2026 at 6 p.m.
Yeah, right.
I attend the meeting. On that day, it was orally informed, that the previous counting venue, which was, there, in Gitanjali Stadium itself, and which has been the counting venue for this particular constituency, Kosba Assembly constituency, this counting venue is likely to be shifted to one, Bihari Lal College, near Alipur. This was orally informed to us. Thereafter, page, from page, this document, one document venue for the last previous years 112. In respect of 149 Kosba constituency, the venue has been Gitanjali Stadium all throughout.
No.
Page 112.
Yes, 112.
Page 112, the first constituency. This is in respect of 2021. This is the counting venue, my lord, Gitanjali Stadium.
Yes.
Now, my lord, this year,
So what is your constituency?
my lord, my constituency is 149 Kosba.
114 Kazu. Yes.
Thereafter, my lord,
This is earlier.
this was earlier. Then, my lord, please see
Earlier means 2021.
21.
Yes.
Then, my lord, what they have done is at P5, page 127. 127
Yes.
on the 28th of April, they say that, my lord, notice regarding post-poll scrutiny of Form 17A and other documents, my lord, from today it is taking place from 11 a.m. My lord, though leave was obtained from your lordship at 10:30 at Bihari Lal College. Now, my lord, the law obliges them two things. Law obliges them, my lord, in terms of Rule 51 of the conduct of election rules. Now, please see. Boy. The conduct of election rules. Now, kindly take the trouble to come to Rule 51. Time and place for counting of votes. The returning officer shall, I'm sorry, my lord, extremely sorry. Rule 51.
Yes.
The returning officer shall, at least 1 week before the date or the first of the dates fixed for the poll, appoint the place or places where the counting of votes will be done and the date and time at which the counting will commence, and shall give notice of the same in writing to each candidate or his election agent.
So returning officer at least 1 week before
Yes.
the date.
My lord, in the fact
First of the date
yes.
fixed for the poll appoint. Place
Now, my lord,
places. Yes.
sorry.
Then
My lord, in terms of this rule, my lord, they have what is known as the handbook for candidates of 2023. My lord,
so but proviso.
the proviso is provided the first part is complied. Proviso is proviso will come into operation if 51, the first portion is complied. There is a date. Lord, I have specifically pleaded in the writ petition that they have never indicated the counting. We all understood the counting venue. Because the previous years, all this time, the counting venue was, some other place, the stadium, Gitanjali Stadium. Now, in terms of this handbook, this is the handbook for candidate. A lot of handbooks have been handed over to your lordship. Kindly see the handbook for candidate. Kindly takes the trouble to come to 14.5.
Yes.
The returning officer shall, I'm sorry,
Yes, continue.
At least 1 week before the date fixed for the poll, intimate in writing to each contesting candidate or his/her election agent the date, time and places of counting of votes as per forms prescribed by the Commission for the purpose vide Annexure 18 or Annexure 19. Annexure 18, your lordship will be pleased to find at page 283. This is this is Annexure 18, is a part of their handbook.
Okay.
It says notice to candidate or their election agents regarding the date, time and place of counting.
Yes.
That is Annexure 19. And Annexure 18 is notice to candidates or their election agents regarding the date, time and place of counting. These two forms has not been issued. As per my instruction, what they are trying to do is, after the election was over, in the light of Annexure P5, because 30th they have convened a meeting. This is a college, a 3-story structure. And they are. We have been told, because my candidate as well as the writ petitioner as well as his election agent was present at Bihari Lal College today. What happened on instruction, I cannot produce documents or photographs because I'm not supposed to. Now, what is happening is they have stacked the ballot boxes and they have fallen down. And the ballot boxes, these EVM machines some of them have been, in a damaged condition. And they are also contemplating to hold the counting without complying with these rules, without complying with Rule 51. They are contemplating to hold the counting at a 400 square feet room, for how many machines? For how many machines?
317 plus.
317 plus EVM machines, 14 candidates as against their election agents and everyone. And this is as against a stadium where there was an expanse, there was a sufficient area, and the area was 10 times the area earmarked at Biharilal College. It was 4,000 square feet which was earmarked. And all these years, Biharilal College was never in the scene in respect of Kosba. Kosba is a place near this Acropolis Mall. The stadium is just beside the Acropolis Mall. Now they are trying to have it where Mr. Chaudhary often goes behind Taj Bengal.
I don't go.
This Biharilal College is beside Taj Bengal. Just to cut it little light.
No, you will go after.
Yes, he'll take
I'm
me.
telling you, you're going. He will go.
Both of us will do. He's going to take me.
I don't know whether he will take to you or not.
That is obviously there.
Yes.
And the strong room even today is at Gitanjali. The counting is taking place there and without compliance with Rule 51.
Yes. That's why.
It's a 8 kilometer away from Gitanjali to Biharilal. That is my sum and substance. They have not complied with their own handbook. They have not done it within 7 days. They are doing it just 3 days prior to the election.
Yes.
No, they won't allow counting. That's the motive. Petition after petition.
No, why you are changing?
Why I'm changing? Note it down. My lord,
Why all controversy you are
no,
creating?
previously there were 5 different counting venues.
But whether you follow the rules.
Yes.
51.
I'll give you give your lordship the logic first.
Not logic. First you said tell me whether you follow the
Yes, of
51
course.
and the 51 and the
His
handbook.
petition shows that I followed Rule 51.
Hmm.
5 different counting venues for 10 assembly constituencies. Now 1 venue. That's the reason, because we have an allied strong room, and that's why the shift. Now, my lord, and it has to be with live streaming, etc. Because this time everything's under, my lord, CCTV surveillance.
No, you had challenged that.
Yes.
You had challenged that that's a tender. You're not there. No? It was came before me. That tender was challenged with regard to CCTV.
That perhaps I had the occasion.
Election coming.
No, he was.
Okay.
Yeah, no. Mr. Bhattacharya.
Oh, Mr. Mukherjee was there.
Yes, yes.
Bhattacharya.
He was there. I was appearing.
No, I wasn't there.
Mr. Mukherjee was there for the election commission.
Election.
Yes.
Yes. Next.
Yeah, but that's not, that tender came before your lordship.
The tender did come.
But tender was called by you.
They are called.
Yes. So, my lord, that's number 1. So this is the administrative reasons. Number 2, my lord, please see paragraph 2. He's a candidate.
You are appearing for election commission?
Yes.
Paragraph?
He's a candidate.
Mr. Naidu is not there. Mr. Naidu is appearing? No. Yes, paragraph.
Paragraph 2, my lord. No, he's there.
Mr. Naidu, you are appearing in the second matter. Unmute.
Yes, Millets, I was just told about it. I'm just trying to go through that one, Millets.
These
Because
are
this
all
is surprise, Millets. Your lordships may appreciate, Millets.
notice we are coming and arguing.
I think we have served them long time.
We need to talk, Millets. We need to talk to the officials, get instructions.
Conducting an elections. This is reality, but we don't come and ask for an adjournment or postponement.
Yes, page, paragraph.
My lord, 2, my lord, he is the candidate. Now, my lord, please have a look at.
Let him show Annexure 18. The matter is over. You show Annexure 18.
I'll
You
show
have done
what
it.
I have to show.
Then I know what you
And-
can't show.
I'll show what I have to show, and you can carry on. My lord, please see, my lord. Paragraph 9. I'm sorry, my lord, he got notice that he is admitted. Paragraph 7. An urgent meeting of candidates called on 27th April. My lord, the notice is annexure P2.
Yes,
Please-
admitted.
Yes.
P2.
So, my lord, candidates were informed.
Correct.
And I'm sure, my lord, other notices must have also gone out. So he was informed of the change. He attended the meeting and he says so. Next page. Paragraph 8. Petitioner states that the petitioner duly attended the meeting on the scheduled date and time when the petitioner was verbally informed that the venue for the counting has been shifted to Biharilal College, Alipur from Gitanjali Stadium, Kosba.
Yes.
He knew he's attended. And if possible, my lord, I'll take instructions. I'm sure they would have informed Mr. Naidu also. whether my lord separate notices have gone, but he was informed. Now, my lord, see Rule 51.
The only apprehension was that Millets, it was 8 kilometers away. Millets, we assured him that all the logistical aspects would be taken care of. Every security measure is put in place. And then Millets, for various reasons, we have been taking these steps with regard to that one. If my lords feel that it should be looked into, give us time, Millets, we'll place every material and also the justification.
Consolidation of counting. 10 centers, my lord, now rolled into one. Everything will be criticized.
10 centers.
My lord, we will not be able to, my lord. Today we are on a Thursday afternoon. My lord, if it's serious, your lordship may always, my lord, pass orders, my lord. That's your lordship's jurisdiction. But, my lord, if it's, my lord, on apprehension, issue is tomorrow is 1st May, a holiday. On all of this, whoever is discharging functions, my lord, they have to be given training. Any order, my lord, will have the effect of, my lord, stopping counting on the 4th, which seems to be the motive.
Okay.
Matter after matter.
Lot
You
of
who will
logistical
count,
issues.
Trinamool Congress will decide who will count. They will decide where the counting will happen. They will decide who will observe the counting.
Okay.
And
And
the
no material.
commission is not going to comply with their own law,
No,
their
no,
own handbook.
no, no,
You know,
no.
let him, you know, I would have
Hey,
gone out
what
of
is-
court. I would have gone out of court if Form 18 was shown to your lordship. Let him show Form 18. Let him show that I was a candidate and I was informed 7 days prior to the date of election.
No, the
29th
proviso,
was
lordship,
election.
is seen.
Proviso comes, we not provided 51 is acted. Proviso comes later. First is 51 act. We not
Proviso is always with great respect. Millets, an exception. That is the purpose of proviso. When exigent circumstances are there,
Mr.
even the
Naidu,
residuary power can be used.
liquidity that I have for him, I will request him to kindly hold his breath for some time. Will not let him show Rule 51 compliance and handbook compliance. Will not I go out of court.
Okay, you give the copy of the handbook.
Will not, yes. I have handed over.
You have handed
I
over.
will, I'll give you a,
Okay.
I'll give you a.
Yes. Anything further?
Yes, my lord, I just.
And Milord, just another thing,
Yes.
insofar as consolidation, Milord, I have indicated in the writ petition, 112 is one document, 119 is the other document. Previous all elections, Milord, insofar as Kosba Assembly constituency, the counting venue always had been, Milord, Gitanjali, and no other, Milord, constituencies counting used to take place there. It is only Gitanjali Stadium and,
Mr.
Yes, yes, you choose where counting will happen.
no, it is.
My lord, please see, my lord,
choice.
please see Rule 51.
Yes, 51.
Especially the proviso Millets.
Yes. The returning officer shall, at least 1 week before the date or the first of the dates fixed for the poll, appoint the place or places where the counting of votes will be done and the date and time at which the counting will commence, and give notice of the same in writing to each candidate or his election agent. Then below the proviso, provided that if for any reason the returning officer finds it necessary to do so, he may alter the date, time, and place or places so fixed, or any of them, after giving notice of the same in writing to each candidate. So, my lord, he's been given notice, he's attended, he said he's attended, and he's been told. Maybe separate notices have also gone out to those who have not come. He's admitted that he's been told.
Yes. That's all.
Lord, absolutely. And Lord, I don't want to, Lord, yes, Lord, please see paragraph 6 also. Whimsically changing the counting center.
Yes.
So, my lord, according to him, there was a counting center which was nominated. Then, my lord, this is paragraph 6, paragraph 7. By this notice, respondent number 8 called for an urgent meeting on 27th April and changed. That's paragraph 8. So, my lord, this is Rule 51 compliance. Originally at the stadium, then notice, then change. There is no anomaly.
Where is the original stadium? That's why that is their contention. Where is the
My lord, please
original-
have a look at paragraph 6.
No, the paragraph 6 is earlier. His contention was the earlier all times it was in the stadium. Now you have issued the notice. You have stated that that will same in the same place, but all of a sudden you have issued.
No, my lord, please see paragraph 6.
Yes.
Petitioner states that your petitioner has been constrained to approach this court challenging the arbitrary act of the respondent number 1 of whimsically changing the counting center.
Correct. That's
So,
why.
Milord, that's the case.
That's why
So
he has made out a case. He has made out a case every time Kasbah was in the stadium, was in a stadium, and on that day he also issued the notice, and he appeared in the meeting, and it was informed that yes, your counting station will remain in the stadium, but you have, so all of a sudden on 28th of April you have issued this notice fixing the counting station at counting place at the other place, and you have not complied with the provisions of the and
So now his case is that there was no original fixation of place.
Hmm.
So the first part is breached. So within 7 days, you can't fix a place for counting.
Yeah, that is the case
So
he
then-
made out.
So that is the case he wants to. But it's not possible. He served now. So therefore, no counting.
Mr.
So
Mr.
what is the argument then?
Mr.
So what will happen?
His case is that why he's not asking for the stay of the counting. Why the counting remain in the stadium?
So let us will not see the prayer made. Let us see the prayer made.
Yes.
I have sent my learned friend to find out whether there was an original area indicated, original place. Lord, please see the prayer. Writ offered in the nature of mandamus, directing, commanding the respondents to withdraw, rescind, cancel, forbear, giving any effect to any order or notification issued by them to change the counting center. So he comes to court and argues that there is no original counting center.
That's why, because that's why he's telling that on the meeting it was informed that since beginning it was in the stadium, so he will remain in the stadium. That is the
No. So he came and that's what your lordship, my lord, appreciated. He came and said first part of 51 is not complied with. So there was no original, my lord, venue fixed. That's his argument. So he can have one argument. His argument is
No, he's telling that in the meeting, once he already stated that it is since beginning it is going in the stadium.
yes.
Correct. It is going in the stadium.
Yes.
So nothing.
So why are you changing?
Yes.
That's his case.
That's his case.
So proviso to rule 51 allows me to change. I'm changing.
Okay.
And the reason is consolidation. No, it's there. They're not saying that. So once let's not be sure of the facts, Milord. He says you fixed Gitanjali Stadium. Then you shifted on the 27th. You shifted it from Gitanjali to Alipur. You could not have done so. This is his case.
Okay.
If this is his case, Rule 51 is my answer. Milord, please, Milord, see.
That's why I put the question to him, proviso.
Milord, for a moment,
Besides
thought
that also,
I thought his case was that no original place had been fixed because he was speaking, my lord, in two voices.
Yes.
But now that he agrees that an original place is fixed, he wants the change not to happen. Answer is, my lord, Rule 51 says, provided that if for any reason the returning officer finds it necessary, he may alter upon giving notice. Now, why do I find it necessary? I find it necessary because there were 5 different counting venues. I am consolidating 5 different counting venues into one venue. So 10 assembly constituencies votes will now be counted at one venue. The advantage of doing so is it is easier for me to ensure, my lord, CCTV coverage because that's, my lord, we are doing it for everything, these elections. Number 2, it is easier to monitor. It is a very, no matter how much we come here and
How many counting station in the stadium?
10 assembly constituencies had 5 counting venues.
How many counting stations are there? Counting places are there?
5.
Total.
No. Last time for
Not
10.
last time. This time, how many counting stations?
For
are
10. 1. So
Total,
we're not 10.
total how many?
Oh, total in all of West Bengal.
Yeah.
In
Calcutta.
Calcutta.
It is a Calcutta.
In Calcutta.
Hmm.
Call up, find out.
So that's why you are giving the biodata.
No. I asked.
You have given the 10. So how many counting?
So no. I am saying 10 assembly constituencies. For these 10, we are now going to have one venue. So the number, I'll just find out.
So-
Find out now.
Yeah, may I?
Notification है जिसमें specifically बोला दीजिए only educational institution and colleges would be used. ये तो देखिए.
Yes, my lord. There's also a notification that Commission has instructed that counting centers should be located at district headquarters or in exceptional case at subdivisional headquarters. Further, so far as practicable, government buildings other than colleges, education institutes are to be registered, keeping in view suitability to establish counting center. So, my lord, it also has to be, my lord, there has to be some proximity to headquarters. In fact, that was what, my lord, the DM had also
Your
said.
instruction in the print. There, you're not a print.
My lord,
You are
they
taking
are all
off.
coming just now, my lord.
Take the
I will
print
just
and
get a
give
print.
the
Go
court.
get a print.
If I will pass an order, then you will go to the appellate court. See, my lord has not
My
considered.
lord,
That is the
no,
problem
my
with
lord,
all of you.
I know, my lord, I know.
All the
but
two matters you have done
please-
this like this only.
But please, my lord,
When this court has given 3 times, you are not submitted, and you went to the appellate court. My lord, see, this is the notification not considered. This is the notification not considered. And now the same thing you are doing here also.
my lord,
See, Mr. Naidu is appearing from the Delhi, but he is having all the documents. Why you persons are not bringing all the documents? I don't know. 2 matters you have done all these things. On one day, I already Mrs. Pandey, I have already directed her, but they're not bringing mobile phone. You can read it. If you are having give the document to this
Sir,
court.
when I have got it, lordship will see, my lord,
If you said that you're not ready, then not to argue.
and allow an order to be
What can
passed.
be
my
done
lord.
then? If you're not placing the document, you
Sir, I have just got
on
it
your
right
own
now.
on your own mobile phone, you are reading
Go
and
get
keeping
it
within your
printed,
pocket.
Go get
How
it
the court
printed.
can do? Court has to send
My
document.
lord, I am getting it, my lord. Its lordship will appreciate when, my lord, the petition.
1 hour you had a time, you are not collected that.
My lord, we are asking, lordship will also appreciate the persons who give us instructions also have some other work. To get them to go to the file, take it out, send it to us. My lord, we are trying our best. My lord,
Yes.
this is the difficulty. Lordship will, my lord, please consider. This is the difficulty we face.
Can be
We are
done.
trying our best.
You are doing the last hours to what the litigants also do. Can you see when the order was issued?
28.
Then what the litigants do? Litigants said only the last hour of the
29th was
court.
election.
My lord, this is
Today
not,
is
my lord,
30th.
a litigant whose rights are, my lord, being infringed.
That the court will see.
Everything,
you
my lord.
can argue the matter, but the court will see whether right has been infringed or not. It is up to the court. You can only submit.
My lord, am I trying to do more?
Yes. Now what you're telling? It is not the infringement.
No, he is, my lord, the sitting. My lord, please see paragraph 2.
What?
My only
So what?
If-
Is the dissent right?
my only anxiety is that once you are making all the submission with regard to the data, you have to come with the document so that the court can record all these things.
My lord, it is, I am trying my best to do that. And the commission is also, my lord, trying their best to, my lord, send us the papers.
Yes.
My lord, if we've sent for a print, it will go to Old Post Office Street, my lord, get it and come back. My lord, this is the difficult. She appreciates our problems also. My lord, service is service in
Yes.
the afternoon.
What is your submission?
কি দরকার?
Because the court cannot pass any order without the document on verbal, and verbal can be changed at any point of time.
In the
And this court has faced, that I am telling. This court faced.
Which is why, my lord, may I, if your lordship will, my lord, please consider.
The appear twice, 3 dates has been given, third advocate on third day, and make some other submission and filing an appeal and
No,
making
no, your
another
lordship
submission.
will also appreciate, which is why the genesis of the law that elections are not to be stopped or interfered with.
I think he is, Milord, completely, Milord, thrown a tangent to the actual matter.
My only question
My
is that
only-
you-
No, no, I am trying to,
I
trying my best to
appreciate-
answer the question.
I appreciate that, yes, with regard to this, you have to show what decision you have been taken. Because all
So
the
to
things,
get,
all the things,
my lord, also, my lord, please appreciate,
when you receive the writ petition,
when I receive the
Your
writ
office,
petition,
your
please
office.
show the email, it goes to the commission. And when we are moving,
Pandey, at 12:27
12:27,
Milord,
2
he was
o'clock,
opened at 20.
yes, 2 o'clock, we are before your lordship. So, my lord, it's less than 1.5 hours to photocopy, scan, send it for instruction, and from 2 I am before your lordship.
okay,
Exactly 80 minutes.
okay. Anything further?
No, my lord, it's,
All the three.
but if your lordship will please, my lord, consider that it's for administrative, my lord, reasons. I have asked the DM, he told me, my lord, that this we are consolidating 10 assembly constituencies in one venue.
Give in writing, 4-line instruction, give in writing. Give in writing.
Give us time till 5 o'clock.
By
He is
5
not properly instructed.
That's
Milord,
Milord, I am,
Milord, it is only one constituency which is going on.
Milord, I have
How many constituency has been given to this school premises?
Biharilal?
Biharila school premises, how many constituency has been given for counting?
just call this person. কোথায় পাঠালে তুমি?
Milord, these are the relevant portions of the handbook.
Calcutta North has 7 seats, counting venue. South has 4 seats, 4 counting venue.
God knows. Huh.
DM doesn't know about Calcutta. He knows
No, no.
about this.
DM South 24 Parganas. Call DM South 24 Parganas, ask him. Milord, I spoke to the DM South 24 Parganas and I wrote down in my hand this.
Whatever it is, what your instruction, give to my court officer, I will.
Yes.
My instructions tell
Three things. Why? What is the reason for transfer? First thing. Second thing, how many constitution has been given, constituency has been fixed for the counting in this said college, and whether it's prior to that any station, any counting place has been fixed.
7 days. Rule 18, 19.
The proviso says it's possible.
That I understand.
But your lordship wants to know why have you done so. So I'll tell your lordship the why. Now that your lordship has given me, my lord,
Now you
at least 45 minutes, I'll get it done. My lord, I had
45 minutes.
Yes, it's 4:15.
Ah.
Your lordship said 5. Give it by 5 to my court officer.
Give to my court officer. Okay, give whatever.
5:10, my lord. With half an hour, 45 minutes, my
share it
lord.
with me also.
Why?
You will not share it with me.
Yes, you give the copy to them also.
Strange. Mr. Chaudhary, we all know.
No, my lord.
What that I have for you.
No, my lord.
Please.
This is, I just obtained a letter from the election commission indicating this. Addressed to the advocate in the form of an instructions and I'll give it.
Give it.
Then I can give my learned
Yes,
friend.
that's right.
Otherwise, it is difficult to give an
That's
official
right.
document.
But I am not asking anything further.
But my lord, my request is, counting is on the 4th. Anything, my lord, we won't be able to count. Elections can't be declared. Results can't be declared. Please, my lord,
Why
consider.
apprehending?
No, my lord,
They are apprehending only why your lordship will not kindly
we want to
because
close it.
they know it that they have not
So lakhs
complied
of-
with
no,
Rule
no.
Part 1.
Please understand, there is a large number of people have worked tirelessly for this process.
Free and fair election.
Correct. Where over 90% people have voted for the first time.
Well, let us not go into these figures. Previous election, 85% people voted.
Please don't.